skin is black. My arms are long. My hair is woolly.
Going public.
Another key point of regulatory. And welcome to another episode of Tech Hour. I am your host, Simone Smith Bean. And today's episode is entitled, What You Didn't Know Until You Know About D.A.R.E Licensing. So, Digital Asset Registered Exchanges Act 2020 came into being on the 14th of December of that year. And the Securities Commission focused on this legislation because it wanted to create a legal definition for the digital asset and regulatory framework. Digital asset business was an important part of the Bahamas' projection for their new entities and new business frameworks that they wanted to be in place for the country as a pillar of their financial services industry. And so the D.A.R.E Act establishes a robust regulatory framework that was designed to, one, protect investors and consumers, align with international standards to combat money laundering and the financing of terrorism, and three, manage and mitigate attendant risk. And so the Securities Commission developed the D.A.R.E Act in mid-2018, and the condition under the act was to ensure that they were able to provide proper legal regulatory framework for the digital asset space. As you remember, when this act came into being, the digital asset space was going through many transitions, and there were so many new startups that would have come out and began operations without any regulatory framework whatsoever. So the Bahamas was trying to be innovative in creating some type of legislation that was going to give people and companies and founders some guidance to be able to obtain licensing and ensure that their operations were going to be met with great standards. And so as the years went on, many of the higher persons who were in the industry would have come and set up businesses right here in the Bahamas. And one such notable company was FTX. But we all know what happened to FTX. And once they began to seek having troubles, there was an idea to go back to ensure that the frameworks that were established previously could find some more robustness. And so the commission went back to the persons who are in the industry and sought further advisement as to how they can strengthen and to create more controls for the industry so that consumers can be protected. And so when they would have done that, the D.A.R.E Bill of 2023 was born. And so in order for you to make an application under the Digital Asset Registered Exchanges Act, there are a few steps that need to be taken by your entity. Now, the Digital Asset Registered Exchanges Act sets out the parameters for such licensing. And the number one requirement set out by the Securities Commission is one. First, they require a copy of the applicant's written supervisory internal controls and risk management policies and procedures. This is your compliance manuals. All of the information that is going to be managing all of your operations, all of your compliance risks, all of the things that are your services that you are offering, all of these things are encompassed in this supervisory internal controls and risk management document. But what you don't know is that this document will be one of the main items that are going to be scrutinized throughout your application process. So you want to ensure that it touches on every aspect of your business, every service to be offered, every onboarding process, every risk that could be associated with your company. You want to make sure that this document entails all of these items. Number two, the Securities Commission requires a copy of the applicant's detailed and up-to-date business plan. Now, If you are a brand new company and you are just establishing yourself and would like a D.A.R.E application, it is best that you would have tested your platform in a other jurisdiction prior to coming to the Bahamas. Because what is not clear through the legislation process is that D.A.R.E is very particularly geared towards operations that have been already established and proven. And so if you're a brand new entity, it would be a great thing if you were able to have your platform and your operations tested prior to attempting to make an application to D.A.R.E so that all of your services provided have been vetted and previously reviewed, possibly by another jurisdiction. And so if you're looking to move your company here from another jurisdiction, then it would be an awesome thing for you to make sure that that previous jurisdiction having licensed you can give you a nice seal of approval so that your license can be recognized and also reviewed by the Securities Commission. But just because you're licensed in another jurisdiction doesn't give you an automatic shoe-in in this jurisdiction in the Bahamas. And so this is just to support your application and to provide further clarity and further support for why your company may be a good fit for the Bahamas. Number 3, copies of your required financial statements. Now, financial statements can mean many things. It can be your sales projections for a few years. It can mean your how much money you're currently making or previous financial statements. Your financial statements really should include, if you are a going concern, your operations up to 3 years previous and including your projections moving forward. Now, this is not so explained in any of the documentation provided by the Securities Commission, but having gone through these applications before, it has become very clear that what the Securities Commission expects is to have proof that your company has had financial wherewithal previously and projections moving forward, which would include your employees, all sales intended for your services to be offered, and any revenues that you seek to be made. And that is going to be very important for them to have a holistic picture of your company to ensure that it's going to be a viable entity for licensing. Number 4, evidence that the company has adequate insurance and regulatory capital. Now, this is deemed to be indemnity insurance for all operations of your digital asset platform. Many persons in the industry know that indemnity insurance is not the easiest type of insurance to get for the digital asset space. And so, as a way to assist organizations with ensuring that they can have the support that is required that insurance provides, the Securities Commission requires a deposit of regulatory capital that would cover all operations for the projected time frame that you present to them. And so if you put 3 years of projections for your company, and which would include all costs associated with operating your company, all business projections for revenues, they expect to have that said amount for 3 years deposited in any financial institution that you intend to engage with here in the Bahamas. And so it's very important to note that a part of your application is to prove that you do have a local banking relationship that is going to support your regulatory capital and that funds are being kept in that entity. And a tie-in to that is to ensure that when you're moving your company here, and if it's not a continuation and you begin to start a brand new entity, that brand new entity, whether it's a subsidiary of an entity you have somewhere else, is incorporated prior to your application. And so that's very important for you to find the right corporate service provider. It might be us here at SBC Corporate Services, or it may be another corporate service provider that you choose. But it's very important that you establish the entity that you're making the said application, because the next step in the process is going to be very important, which is at number 5, an organizational chart. An organizational chart is a picture of the firm and all job descriptions of every person who's going to take an executive role in your business. And many companies make the mistake in the beginning of having all of the persons who are intending to operate their entity remotely. But the Securities Commission requires that many of the executive team must be resident or present here in the Bahamas. And so if your executive team is currently outside of the Bahamas, then applications will have to be made for that executive team to seek work permit and get approval from the Bahamas Investment Authority for those persons and your company to move base here in the Bahamas. And that will be an important aspect of your application because a part of the requirement is to ensure your executive team is here and present, living in the Bahamas, so that there is someone who the Securities Commission can rely on to ask any questions that are necessary about your operations. And now moving on to number 6. You must also provide evidence of the applicant's good standing as it relates to the companies. That ties right into my point about number 5 and ensuring that you have an entity that is already established here in the Bahamas. The company must be local. And so if you wish to have your company move from another jurisdiction as a continuation, an application can be made to the Registrar of Companies in order for that continuation to be established, or a new entity can be set up. Once that new entity is set up, a good standing document is provided to the company by the Registrar of Companies, and that then shows that you are in good standing with the regulatory requirements of the ROC, which is the Registered Office for Companies here in the Bahamas. And moving on to number 7. A certified copy of the applicant's memorandum and articles of association. This comes along with the incorporation of your company. If there's continuation, this can come from another jurisdiction that you are taking your company to continuation here in the Bahamas, but establishing a brand new entity is always a great rule of thumb so that you have all the necessary documents in the beginning when you are prepared to send in your application. In addition to that, please note that all applications, have to be also accompanied with any previous licenses that you may have in other jurisdictions. And if your company is owned by other companies, then all of the background information about that company, meaning all of the company documents, all of their shareholders, all of their due diligence has to be provided as well. And so if this company that you establish in the Bahamas is not wholly owned by one person, but wholly owned by an entity, all of that entity's information is going to be relevant to your application and must also be provided to the Securities Commission of the Bahamas for their review. And number 8 on the list. A schedule of proposed fees and services rendered by your business. This is going to be important because they expect all services rendered and fees associated to actually be present and available to your customers. And so this must be available also and accessible by the Securities Commission and provided through your application process. So ensure that you would have thought of every service that you intend to offer. You have a fee associated, and if there are 0 fees, then that is also delineated in the documentation. But you want to make sure that this is created and drafted on a document that can also be submitted with your business plan and any technical documents about your platform. And moving on to number 9 on the list is evidence of the applicant's registration with any and other regulatory authority. Now, we talked about this before. Again, very important to make sure that you have with you submitted with your application any approvals or licenses obtained in other jurisdictions. This again will support your application to the Securities Commission. And moving on to number 10 on the list, completed Form 2, first schedule in respect of each founder, beneficial owner, significant interest holder, director, officer, applicant in digital asset business. Now, in addition to Form 2, you also will have to complete Form 1 and Form 3. that is also available on the website, but not included on the list of things that have to be submitted. And so, to ensure that you have completed your application, each person on your executive team, members and directors and beneficial owners must complete Form 1, Form 2, and executive members must make sure that they have completed that Form 3, and that includes your CEO, your compliance officer, and any chief legal officer that you may hire for your entity. A great rule of thumb is to ensure that you have those 3 rules set out for your entity for operational purposes and licensing. You can easily add additional persons that are necessary for your operations once licensing is preliminarily approved. But in the initial stages, when you make your application, each one of these applications are important, and the forms are important because it provides the Securities Commission with the information that they need to know as far as who will be responsible for making their operations happen, and who will be responsible for your compliance implementation, who then will be responsible for your legal implications. And so those particular points are very key when making your application to the regulatory authority here, the Securities Commission of the Bahamas. So be sure to ensure that when you're making your application, you are well informed as to all of the information required. One additional point to note is that the Securities Commission has a blanket rule. Any information that they require, that they deem necessary for your application, can be requested. This can be anything. Once they read and review your application, they will also come back with a number of questions, a number of additional requests that may not have been in your contemplation. So don't get discouraged when you are going through your application process. This is a process. And to ensure that the best company comes forward with the most robust systems and services that can be offered to the public is what their goals are. And so to ensure that you are successful, be sure to have enough information that is provided in the beginning. Be sure to be very well versed on every aspect of your business and all services intended to be rendered, and any documents that you know that you need to provide or obtain time to provide, they can certainly provide that time sufficient to you. And now, when it's time for you to have your preliminary license approved, another important point is for you to note that your operations has to be local. So that means establishing a physical presence here in the Bahamas with an office that has physical staff. So you must plan to ensure that you are moving forward with setting up a physical location and operation here in the Bahamas. And that will assist you getting past any other additional requirement for licensing and further inspection that may be required for you to keep your license. And in addition to that, will be new policies and procedures that are going to be required as a result of the new act that should be coming into force very soon, the D.A.R.E Bill of 2023, which is currently before Parliament for approval. And so if you want to have more information, or you'd like to learn how you can have your company be registered here in the Bahamas under the Digital Asset Registered Exchanges Act, please be sure to reach out to us at info@smithbeanlaw.pm or admin@smithbeanlaw.pm, or you can visit our website, www.smithbeanlaw.pm, and we can easily answer any questions you need to know about D.A.R.E and all the things you didn't know until you knew about D.A.R.E. Until next time, I'm your host, Simone Smith Bean, and this is another episode of Tech Hour. Be great.
My back is strong, strong enough to take the pain inflicted again and again. What do they call me? My name is on Sarah. My name is on Sarah.